Hello, I'm Henry Quillian. We're here at Taylor English Duma in Atlanta. This is Litigation Fundamentals with Henry Quillian. And today we are going to be focusing on an overview of the various court systems in Georgia. Georgia has been around for a long time, and during the course of history, the Georgia legislature has come up with quite a number of courts. They each have special purposes. They have special people, some people perhaps even more special than you might imagine. Here at Taylor English, we are providing general information for the benefit of the people in the room and also for people who may be watching this video. However, you should always rely on your own attorney in doing research to determine whether this information we're providing is correct. We are not providing legal advice to you. And as you will hear from the discussion today, even within the realm of which courts there are in Georgia, they are forever changing and their jurisdiction is forever changing. So what is true today might be not true in a year. Hopefully we're at least up to date as to what's at least on the plate for the Georgia courts today. So to start this off, I would like to see a hand of everybody in the room who believes they could be a judge in their county today if they were to try to seek such a position. All right, what I'm not seeing is the hands of a younger attorney or a paralegals. Why can't paralegals be a judge in Georgia today? The answer is they can be a judge in Georgia today. There are several courts that we will go over where there is very open opportunity for people to actually be a sitting judge in Georgia if you are in a county that allows it, and that would include what we'll go over in more detail, magistrate judges and probate judges. It's so long as you have residency in your county for a sufficient period of time. And although I don't want to embarrass anybody, as long as you're at least 25, you can satisfy the conditions for being a judge. Is there anybody, well, I won't ask whether anybody's under 25, even though I'm sure some people probably are younger than 25 here. At least they look that way. In any event, so what we need to start with, of course, is that where did Georgia come from? Does anybody know? What was Georgia before it was a state?
Colony.
Okay, it was a colony. And then what did we come up with in order to make ourselves a state once there was a union to be a state in?
Constitution.
A constitution. And then what does the Constitution make as far as the three branches of government? What are they? What are the three branches of government?
Judicial, Legislative,
Legislative.
Okay, yeah. So, and then which one of those can make courts?
the legislative.
Legislative, okay. So, and how creative can the legislature be in doing something?
Very.
It can be very, very creative. And what is its only restriction as to how creative it can be in making something like courts? The Constitution. But the Constitution isn't particularly restrictive in Georgia. So since the legislature can be very creative in creating courts, and in the grand scheme of things, as far as states in the United States, how old is Georgia?
Old.
It's old. So that means that the legislature has had a long time to be creative concerning what the courts can be in Georgia. And then if you even think about it a little bit further, within Georgia, other than counties, what type of public entities are there?
Cities.
Cities, municipalities, and did you know that they can make courts? So if they make courts, that's usually by ordinance. So there are lots of people that can make court things and lots of entities that can make courts in Georgia. And did you know there are over 400 courts in Georgia that are not created by the legislature, but are created by municipalities? So there are lots of places that you might end up if you're in a legal situation in Georgia. Now, we as commercial lawyers tend to end up in fewer than those 400, but we could have clients that end up in any of them, or we could have a client that needs help in any of those courts. And so it's important for us to be able to figure out, okay, where is this situation to land if it's to go to court? Where has the client landed if they are in court and they call you up and they say, hey, I've got this thing, it's stuck on my door, and how do I resolve it? Who do I go to? Who's in charge of this? And then we need to think about how do we get, if we end up in one place, what are our avenues to get to another place if we don't like where we are in court, or if something goes bad in the first setting, how do you get to another setting? Now, we're not going to cover all that today, but it's good to know which types of courts there are that exist in order to figure out where you are and where you can go to. Who knows what the first court was in Georgia, the first county court? I think it was the superior courts. In other words, I know according to my cheat sheet here, the Supreme Court was not actually even come about until 1835. And so before that, there were superior courts. And where do superior courts reside? What are they associated with? As far as a jurisdictional frame? Counties in Georgia, and how many counties do we have?
159.
Okay, 159, is that?
Yep.
And then, is there a superior court in every county?
Yes.
Yes, there's a superior court in every county, but is there a judge for every superior court in every county?
No.
No, because in the superior courts, big counties, they may have their own superior court judge. When I mean big counties, counties with a lot of people. And then in smaller counties with fewer people, there are what's called judicial circuits. And judicial circuits may have one or more judges who ride the circuit and who actually go from one county to another. But, and I don't know that I can say from personal memory, there's a requirement that court actually be held, oh here it is, in each county at least twice a year. So if you are in a county that has very little population, it may be the superior court, even though it is there, only holds court twice a year. But if you were to file a lawsuit in that court, you might actually end up going to the neighboring county to have your hearing heard regarding the matter that was filed in the other county. Because I believe in that instance, the judges can set their hearings where they want them to be, except for in other, limited circumstances. And certainly, I think that might also include criminal trials. That I think there might be the right for a defendant to be in an obligation, really, for the defendant to be tried in the county where they reside. Okay, so what are the other types of major trial courts? Let's first of all, let's talk about the superior court. What sort of jurisdiction does it have? And think about the fact that it was one of the first court.
Everything, civil, criminal.
Broad jurisdiction for resolving all sorts of things. Every kind of crime, right, including all the way up to capital crimes. And then also, what about commercial matters, civil matters? Can you have any kind of civil matter in superior court? And then you can also have a special jurisdiction called equity jurisdiction. Anybody give an example of an equitable remedy?
Injunction.
An injunction. And that's, put it simply, for those out there in the world, you could say that's when one party is wanting the court to order another party to do something, either to stop doing something or to start doing something, or to divide something up in some sort of equitable fashion. And the superior courts, does anybody know if they have the exclusive jurisdiction over equitable matters at the trial court level in Georgia involving the average case?
Yes.
Yes.
Okay. And there, I think there might be, I don't know exactly how it works out as between them and another court we're going to discuss, which is the probate court. But I don't think the probate court can issue injunctions, but it can issue rulings that may be considered to be similar to injunctions. So Superior Court, you can find a way to file a lawsuit in Superior Court in every county in Georgia. And these days that's done how? As of this year? Electronically. Okay. So that does not mean you have to actually go to that court to bring a lawsuit. However, there are other things that have to be filed in Superior Court that are not electronic. What type of things are those? Randy knows all about this.
The garnishments?
Well,
To an extent.
it may be garnishments, it might be real estate filings, right? And so you need to take into account where you might need to file something relating to real estate and whether the person's going to be there when you show up to file it. So always think in advance before you go driving all the way across the state. Make sure the courthouse is open, that it's going to be there, and you might do a preliminary call because we have at least one instance where an unusual number of filings were in a very unpopulated county, and the story was the clerk has had papers piled all over the place because they're used to one deed a day or something like that. Instead, they got hundreds, and that can affect how fast your real estate filings can get accomplished, obviously. So, what type of trial can you get in a superior court if you want one? Jury trial. Okay. What other courts in Georgia are available for a jury trial? State court. But aren't these all state courts? This is a capital S state court, right? And then what other courts possibly can you possibly get a jury trial in? Probate court. We'll go into that. So what is a state court? A state court is a court in a county where the county has decided that they have enough civil cases and smaller criminal matters, non-capital criminal matters, that they would like to form a court that is not as broad jurisdiction as the Superior Court, and they have to partially fund those state courts. So therefore, it's a county decision as to whether the court exists. And what sort of things are covered, and this is there are counties where you may think there's a state court, but you actually have to check in advance because you might say, oh, well, let's just file this in the state court, it's a car wreck case. And then you find out, well, there's only a superior court in that county. So what sort of cases can be heard in state court?
Misdemeanors
Misdemeanors, which would be smaller crimes.
and civil, personal injuries, general civil matters,
Okay, general civil matters like personal injury, breach of contract,
collections.
elections.
Collection.
Okay, I was about to say collections because I believe that elections are reserved to other. So that's it. It may be, are you entitled to as large a jury in state court as you are in superior court as far as the number of people on the jury?
Not automatically.
Not automatically. You have to do what?
You have to file a motion and request for a jury of 12, otherwise you'll get 6.
Okay, so in superior court, you automatically get 12 on the jury, is that right? And then in state court, you have to actually ask the court to afford your client, often the defendant, a full jury of 12, although the plaintiff can request a jury of 12, right? One thing we didn't actually discuss is, so if you wanted to be a judge in the Superior Court of a county, can paralegals be a judge in the Superior Court?
No,
No, and why is that?
you have to be a member of the bar.
Okay, for a Superior Court, a candidate must be at least 30 years of age, must be a citizen of Georgia for at least 3 years, and have practiced law for 7 years. So that means you can actually be a Superior Court judge, which is a very powerful position after only 7 years of practice. But you do have to be 30 years old. Well, chances are, if you practice for 7 years, you're going to be 30 years old, right? All right, and how about for state court? What are the conditions of being a judge in a state court? I don't expect you to actually have that memorized, but you'd have to be at least 25 years of age. Again, state court judge is a very powerful position. They can run trials that go into the hundreds of millions of dollars. So think about whether you want a 25-year-old being your judge. But then again, you also have to practice law for at least 7 years. So either you're going to be a child prodigy 25-year-old, or you're going to be an older lawyer before you can become a judge in the state court. And you have to have lived in the state for at least 3 years. A little bit of facts. There are 109 authorized state court judgeships, and approximately half of the positions are full-time and others are part-time. Now, so if you have a state court judge in a county, what can that judge do other than with his or her law degree, other than be a state court judge?
Practice law.
He or she can practice law in the state. Can they bring a lawsuit in state court in their own county? The answer is no, at least according to this information, that you can practice law, but you can't practice law. It's usually if the county has a part-time state court judge, they make it only one, possibly. It's really not good to be both judge and the advocate. But also, I believe there's a prohibition against being a lawyer in the state court in which you're also sitting as a judge. How about a Superior Court? Can Superior Court judges practice law while they're a Superior Court judge? No, they're not supposed to do that. How many judges actually might you think, if you appeared from a long distance away and you were before the Superior Court judge, might you think that the Superior Court judge is practicing law for the local person? Possibly. So you got to be careful about that. But the Superior Court judge cannot practice law while also being a Superior Court judge.
So I have a question, because I've gone to Superior Court, gotten ready to argue something, and then realized the Superior Court judge is not there. It's a magistrate judge who's coming into Superior Court and who's taken over the case. How does that work? And are they following these requirements and et cetera? I mean, do you get to stand up and object and say, hey, you look young? I mean, how do you get the Superior Court judge? I mean, you file in Superior Court because you want a Superior Court judge. How do you get a Superior Court judge if they just randomly throw a magistrate judge up there?
Okay, I'm going to repeat the question so I'll make sure it's picked up on the video. But the point has been made that you can go to Superior Court. You can think you're before a Superior Court and a Superior Court judge, a judge who is actually either appointed by the governor or who has been elected to be a Superior Court judge, and yet there is a magistrate judge who is sitting on the bench when you show up to argue your motion. And the person may be 25 years of age, not likely. So how does that happen? Does anybody know how that happens, that circumstance happens?
Magistrate judges sit by designation.
Okay.
Superior Court.
Yeah, so the Superior Courts can appoint magistrate judges to sit as Superior Court judges. We'll go into what magistrate judges are. And I believe that has to be done maybe by the chief judge of the Superior Court, if it's a Superior Court where there are multiple judges. But that can result in the designated magistrate judge trying the case that you thought you were going to have before a superior court judge. While we're on this topic, has anybody ever tried an actual case before a magistrate judge while sitting in a superior court? Okay, I have. We got 2 others here. Are you in a superior court or are you in a magistrate court if the magistrate judge tries the case while you're in the superior court?
Superior.
The answer is superior court, okay?
I said, did you consent? Did the parties consent to the magistrate to sign the case?
Okay.
Because I know in federal court, part of the forms you fill out, one of the questions is, do you consent to having a magistrate judge?
Okay, the question is, can you consent to having a magistrate judge
Or do you have to?
sit as the superior court? And another question is, flip side of that, do you have to consent to that?
For the trial, for the magistrate judge to try?
And the answer is, I do not know. I've actually never heard of it being done by consent. I believe that you would have, by the time you got to trial, except for under limited circumstances that are probably defined by local rule or ordinance or whatever, that you probably have to have a superior court judge try the case. But I don't know that, and I don't know that you can consent to having that magistrate judge be in lieu of the superior court judge. What I do know is I've actually tried a case in superior court with a magistrate judge, and it was a bench trial, and I'll go into that. But it can be a troubling thing because you think you have Judge A and you end up with Judge P as your judge, and trying to explain to after you've gone through a long discussion with your client about this judge and why this judge is a great judge to have, and we're going to present it this way because this judge likes it presented that way, and then you end up with an entirely different person being the judge. And I don't think it does not follow the federal system. I don't believe so. Okay. Yes, ma'am.
Now, Henry, would you venture to say that when superior court judges designate magistrate judges, it's for cases that they don't want?
Okay. But I venture to say that when superior court judges appoint or designate magistrate judges for cases they do not want. I'm not sure I would say that. It seems to happen a lot of times just because that's the way it's done in that county. I think some counties do it a lot more than others. And I'm not sure that the judges actually know which cases they're designating the magistrate judges for when they do it. Does that mean that doesn't happen because the judge doesn't want to mess with the case? I don't know. But I think it could go either way, and I'd be interested in anybody's experiences. But I don't know why anybody would want to not have me on a case, and yet you get magistrate judge. Okay, I'm going to keep going through the judges, and we'll go back to possible war stories later. So, one thing to point out, though, and we'll get to magistrate courts, but that is not a court where you can have a jury trial. So, it's conceivable that you would get a magistrate judge who hasn't tried a lot of jury trials. We've already mentioned probate courts is another court where you can potentially have a jury trial. The probate courts used to be called the courts of the ordinary, and the principal thing you think of when you think about a probate court is disputes over wills, the probation of wills, the administration of estates, the appointment of guardians, the involuntary hospitalization of mentally incapacitated adults. They can also issue marriage licenses. Interestingly, and this came up a minute ago, they also supervise the printing of election ballots and the counting of votes. And in some counties, they have jurisdiction over traffic and compulsory school attendance laws. So the probate court is sort of a very interesting mixture of perhaps picking up subject matters that are core to the probate court, and then subject matters miscellaneous subject matters that have been foisted upon the court, because they also can hold habeas corpus hearings and preliminary criminal proceedings. Now, what do you have to do how do you qualify to be a probate judge? What do you have to have in fundamental requirements in a random county in Georgia? Okay. How old do you think you have to at least be?
25.
At least 25, yes, you have to be at least 25. Because they know all about wills, those old people that are 25. And then you have to be, and what sort of education do you have to have?
High school.
High school graduate, you have to be a high school graduate. And how many years do you need to have been a county resident? 2 years. And I guess that's because for people to have somebody deciding on whether they inherit the back 40 or not, they want that person to be at least 25, to have a high school diploma, and also to have lived in the county where they no doubt know all about the local politics for at least 2 years. So, how powerful do you think a probate judge could be as far as affecting the rights of the people in the county?
Very powerful.
Could be very powerful, right? And so, but nevertheless, that's what the requirements are. And how many years can they be a probate judge, and how do they get there?
I feel like for life.
Okay, but they're elected for 4-year terms. All right, and they are in countywide. I found this to be interesting. Partisan elections. Unlike Superior Court, which is nonpartisan, and State Court, which is nonpartisan elections for the judges. So I guess you would have a Republican candidate for probate judge, and a Democratic candidate, and a Libertarian, and then they would be fighting it out. I'm sure they have caucuses and debates in the high school and all sorts of things that lead to them being elected. So what happens, however, if you get to a county that has over 96,000 people in the 1990 census or the census thereafter? Okay, you end up with what I call a super probate court. Basically, once you hit that large of a population, the probate court has a number of changes to it. One, it becomes a court eligible to try jury trials. 2, it changes the place from which, or to which you appeal from a probate court. And that is tied to, I think, the fact that you have a right to a jury trial in the probate court. So one thing you have to check if you're going to do something outside of the metro area where we have 96,000 people in, I think, all the main metro counties, is you better check to see what the population was in 1990 of the probate of the county where your probate court is, that you might need to do something. Because 1, it affects whether you can have a jury trial or not, and 2, it'll affect your appellate's rights, and 3, it may affect what judge you might have. Because if you have a county where there's more than 96,000 people, a candidate for probate judge must have practiced law for at least 7 years and be at least 30 years of age. So, in a super duper probate court, big county, it's very similar credentials to both state and superior, and the court can have jury trials. So if you come from a lower, let's say a more rural county probate court, where would you appeal if you had a decision that was adverse to you? You go to Superior Court. And if you go from if you're in a county with 96,000 people and you could have had a jury trial in probate court, where do you appeal to? It's the Court of Appeals. So it makes a big difference where you start, how you got there, what the status was, and where you can go from there. Okay. There are juvenile courts. Now we're going to talk about the courts that you don't have the right to a jury trial. Has anybody heard of a juvenile court? Now, does that mean the court is young? No. It means it's the courts where matters relating to principally people that are they're 17 years and younger have things resolved regarding them. That includes matters regarding delinquent children, quite a number of crimes that might be undertaken by a younger person, and the deprivation of children under the age of 18. So for some matters, the cutoff is 17, and for other matters, the cutoff is 18. So if you're talking about somebody that's involved in the matter, oftentimes it's a criminal matter of some type. It depends on what kind of case it is as to whether 17 is the cutoff or 18. Now, what about this? Can people that are younger that would otherwise fall within the juvenile court jurisdiction, can they be tried as adults?
Yes,
Okay. And why do you say that so fervently?
because I don't agree with it.
And and if they're tried as adults for, let's say, a capital murder case, where is that trial?
In the Superior Court.
Okay, so that would go to Superior Court. So, if you're a underage person and you're charged with a crime, where do you want your crime to be heard? More than likely, juvenile court, because that means there's probably better potential outcomes for you. Strangely, the juvenile courts have jurisdiction over minors committing traffic violations and other special matters. So, how would you become a juvenile court judge, and for how long can you be one?
Well, I know in Texas you get appointed, because my god sister just got appointed to become a juvenile judge. I don't know what happened.
Okay, what do y'all think about how do we get juvenile court judges in Georgia? They are appointed by the Superior Court judges for 4-year terms. And they have to be at least 30 years of age and must have practiced law for how many years?
7.
No, 5. I suckered you in. What do you have to do when you're in doubt? Read the rules. Okay. So there are apparently 120 full and part-time juvenile court judges who hear juvenile cases exclusively. And then full-time juvenile judges cannot practice law while holding office. So the part-time ones apparently can, the full-time ones can't practice law, they have to be just juvenile court judges. Okay, so what is a magistrate court? Another court where you can't try a jury trial.
Small claims court.
Small claims court, which also does,
Traffic.
it does minor criminal violations and like search warrants, county ordinance violations like erosion control, such as that, misdemeanor deposit bad check accounts, bad check claims, dispossessories. And so it handles a lot of the things that a lot of people run across during the course of their lives having to deal with. And there's a breakdown between magistrate judges and chief magistrate judges. And chief magistrate judges are elected in partisan countywide elections to 4-year terms. And then in some counties, the chief magistrates run in nonpartisan elections. So there's apparently local legislation that affects how magistrate judges are actually elected, the chief magistrate judges. So can magistrate judges practice law while they are not sitting on the bench?
I think yes.
Yes.
Okay, the answer is yes, and why? Because we've done a lot of them right across.
Yeah.
Except if they're not lawyers.
Yeah.
because they can be a magistrate judge if they are how many years of age?
25.
25, and if they have what kind of degree?
High school.
high school diploma. So they can meet those requirements. There are 159 chief magistrates and 346 magistrates in Georgia.
So that brings me back to my point. If you're in Superior Court and you nominate a magistrate judge who doesn't even have a JD, isn't there some way that you can say, respectfully that this is contrary to the rules and, you deserve a Superior Court judge? I mean, how does that work?
I don't know. The answer to the question is, if you end up appearing in court and there's a magistrate judge there who doesn't even have a law degree, can you say, I want a different judge? And I would suggest that you could probably file a motion and jump up and down and say, I've got to have at least a lawyer on this matter. I really don't know. I didn't look into that issue. I don't think I've ever had one that I've appeared before that was not a lawyer. In fact, most of the magistrate judges that I've been before who were sitting as Superior Court judge were, very accomplished lawyers. So of a number of years. So the one I had was it was a case where a billionaire had married an additional wife, and he got into domestic violence action with her, and the case was filed by her and the Superior Court, and a magistrate judge was appointed as the judge, and we tried the whole case. It ended up being a week-long case with counterclaims. And the reason why that became important was there was a subsequent, that case ended with a ruling judgment, and then the other side brought yet another case, and we claimed that because it was a Superior Court, general jurisdiction court, case was fully tried, everything that was brought up in the second case could have been brought up in the first one, that there was a res judicata as to the issues in the second case. So we moved for summary judgment to eliminate the second case. So I do know this, based on that research, when a magistrate judge sits as a Superior Court judge and you try a case as if it was in normal Superior Court with a fully in place Superior Court judge, that it is a ruling of the Superior Court. It is not a ruling of the magistrate court. But I don't know exactly how you get rid of a magistrate judge if you show up to argue before one and you don't like the fact that it's a magistrate judge. I would have to say, if it's a complicated legal matter and the person has behind them, proud graduate of XYZ high school only, then it seems like there should be some sort of objection that could be made. So, magistrate courts, what happens if you have a civil claim in magistrate court and you want to appeal it?
Appeal to state or Superior Court.
Okay, you appeal to state or Superior Court. What happens if you have a $25,000 claim that you want to bring in magistrate court? Can you do it?
No.
Okay, you cannot assert a claim for over $15,000 in magistrate court. Can you discount your claim in order to keep it in magistrate court?
Depends.
Yeah. Okay. It depends. Why does it depend?
Some counties will allow you to, and some counties will not.
Oh, okay. So
I did that research. I found on websites, different counties apply different rules. I don't think per the rules that you can, but there are counties that will allow you to do that.
okay, so
And it's on their website. if you want to see.
Mr. Carter says the county website will often express whether the county gives permission for you to discount a claim in order for it to be held.
Not always, but often you have to look around on the website. If they have a good website, you might be able to find it.
And if you are in magistrate court and you're the defendant and you happen to have a $50,000 counterclaim, what happens if you bring your counterclaim?
It can be removed.
You're going to get kicked out of magistrate court and either into state or Superior. I think the natural course is to state, but I don't know for sure if that's a given or whether you can request Superior. But how about this? What if you want a jury trial for your case? If you demand a jury trial, what happens? Your magistrate court gets moved up to state or Superior Court as a matter of right and as a matter of dictate of the rules. So, So let's throw it out there. How many, now we're going to talk about statewide courts not directly associated with a county alone. How many different statewide courts are there that are not specifically associated with a county?
Are you talking about appellate courts also?
We're talking about appellate courts. We're talking about courts.
Supreme Court, Court of Appeals, there's the business court around here, I can't think of the name.
Okay, Mr. Carter has nailed it. The Court of Appeals, the Supreme Court, and the Business Court. And I happened to get a primer on the Business Court this morning by the new and only Business Court judge. So the Supreme Court, as I mentioned, was founded in 1835, and the Constitution says that everything is supposed to be before the Supreme Court, all appeals, except those determined by law to go to other courts. And do you think the Supreme Court likes to have all the appellate cases in Georgia?
No.
No. So we're talking about paragraph, well, boy, it's Article 6, Section 6, Paragraph 3 of the Constitution. Says, unless otherwise provided by law, the Supreme Court shall have appellate jurisdiction of the following classes of cases. And it lists cases involving title to land, all equity cases, all cases involving wills, all habeas corpus cases, all cases involving extraordinary remedies, all divorce and alimony cases, all cases certified to it by the Court of Appeals. That means when the Court of Appeals asks the Supreme Court, what's the answer to this question? And all cases in which a sentence of death was imposed or could be imposed. And review of all cases shall be as provided by law. So, what did they do in 2016? What did the legislature do? They carved out quite a number of those cases and gave them to the Court of Appeals to include divorce cases, cases involving wills, all equity cases except those cases concerning proceedings in which a sentence of death was imposed or could be imposed, and those cases concerning the execution of a death sentence, cases involving title to land, all cases involving extraordinary remedies except those cases concerning proceedings in which, well, that's the same thing, except those cases about death sentence, all divorce and alimony cases, and all other cases not reserved to the Supreme Court or conferred on other courts. So, what did the Supreme Court keep? Given the fact that basically all the cases that were supposed to go to the Supreme Court, except as otherwise provided by law, are now otherwise provided by law to go to the Court of Appeals.
Capital cases.
Kept capital cases, capital debt, capital sentence cases, and what other kind of cases? Constitutional issues, and certiorari, meaning cases that the court chooses by its election upon having received an application for certiorari or petition for certiorari. So the Supreme Court's jurisdiction by this legislation dramatically reduced the amount of cases that will go directly to the Supreme Court. So don't forget, the law changed with respect to the Supreme Court's direct appeal jurisdiction. What happens if you appeal to the wrong appeals court in Georgia? You thought it was this one, but instead it was that one.
Usually it gets kicked. It gets kicked
Okay, it gets kicked where? Back
to the other court.
Okay, thankfully it gets kicked to the other court and not back to you. Because it's depressing to get everything you just filed with an appellate court sent back to you after the deadline is run. So, and sometimes, at least in the olden days, some cases ended up being hot potatoes. The Court of Appeals would say it's this type of case, send it to the Supreme Court. The Supreme Court said, no, it's not that kind of case, send it back to the Court of Appeals. And so that makes a lawyer think, well, how am I supposed to figure it out if they can't figure it out? But Anyway, so what if a superior court issued an injunction utilizing its equitable powers, requiring Al Hill to stop eating permanently? Where would be the appellate jurisdiction if he wanted to appeal that ruling?
Court of Appeals?
Well, if you claim it's a death case, you take it.
Right, that's right. So you don't really know, because since it's a permanent injunction against him eating, which ultimately will result in death, is that not the equivalent of an execution, basically?
But he still has the drinking exception.
So-
It might not be a death case.
So this is one place where we decided that it's questionable whether you go directly to the Supreme Court. Now, if you're dying really quickly, where do you want to start?
Supreme Court.
Supreme Court is my guess, because they may also think that's an extraordinary remedy. And they'll kick it to this, hopefully kick it to the Court of Appeals, which if you file at the Court of Appeals, what might happen? Might end up in their stack of papers for endless days, whereas the Supreme Court has fewer cases coming to it and more people to look at them, so you might get quicker remedy. Okay, we will not go into the appellate jurisdiction or how to get to the appellate courts, except to say some cases are direct appeals where you, if you're leaving a trial court like the Superior State Court, you can just file a notice of appeal and the case will go to the appellate court that you're designated. But there's also what's called discretionary appeals, where you have to actually make an application under a rigid time frame to the appellate court to get that court to try to get them to take your appeal. And there's a long list of those cases which are found in, I had it all printed out here, 5635, I believe, OCJ 5635. I didn't bring that down here, but make sure you read those carefully and all the citations, because frankly, the appellate court clerks don't necessarily follow the language of the statute. They sometimes follow more closely the language of the court saying what the statute says, even though it doesn't say that. So you need to take the most conservative route as far as getting your appeal. And you can file both an application and a direct appeal. And if you file both, if you file an application and it's supposed to be a direct appeal, the court will just say, thank you, this is a direct appeal, we'll keep it. Whereas if you file a direct appeal and it's supposed to be an application, they will kick it out and say, so sorry, you're too late, you don't get to do this. I'll also point out that I found, for those out there in the world, a citizen's guide to filing appeals in the Court of Appeals of Georgia, which is a brand new December 2019 publication on the Court of Appeals website in Georgia. You can see it's short and sweet, but it has a lot of forms you can use. It has a lot of explanations. It says this is not the law, but it actually goes through a pretty good description of what you need to do in this circumstance or that circumstance. So it wouldn't be a bad place to start looking if you have to file an appeal to the, and it actually goes into the type of briefs, what the segments are, gives sample briefs, part 1, part 2, part 3, all that stuff. And this is actually published by the Court of Appeals, so it could be an extremely helpful tool. Any questions or anything for the good of the order? All right, one question.
I know it's a big subject, but administrative law judges in Georgia, generally, what are they deciding? And where do you appeal if you don't like the outcome?
Okay, so this is a topic way too broad for today, but the question is, administrative law judges, which would be those created by an agency or some other sub-jurisdiction of the state or municipality, they of course issue legal rulings which can be very consequential to your client. And it might be as a workman comp's decision, or it might be a zoning decision. But rule of thumb is you have to establish your record before that person, before they rule. And that I believe in very recent history, in the last year and a half, the Supreme Court has ruled you actually have to take up all those appeals by certiorari to the Superior Court, which means you have to get a whole bunch of papers together, including a signature of the person who ruled against you, certifying the case for appeal to the Superior Court. Then you have to apply to the Superior Court, which is very difficult, I think extremely limiting of appellate jurisdiction up the chain.
Well, is that a change? Because I did one like a year and a half ago. We had a direct appeal as a right to the
Yes.
Superior Court.
Yes, that's a change.
Okay.
Yes, I can't remember the name of the Supreme Court case, but it caught so many people off guard. You know, there were a lot of cases they had previously said you're supposed to do it by mandamus, and then they changed it, and there was a Supreme Court decision on that, and they flipped it and said, oh, don't do it by mandamus, you have to do it by certiorari. And since there were a lot of cases already pending on mandamus, it caused a lot of heartache. So if you're doing anything that's coming out of a smaller jurisdiction, like an administrative law judge, a zoning hearing, anything like that, and you never better super be on your toes, because you have to both get the ruling, you have to get all your papers together, you have to file your cert, and you have to get the signature of the person that ruled against you, who often goes on vacation immediately upon a ruling against you. And so be very aware of that. Okay, we're going to call it a day. Thank you so much for coming to Litigation Fundamentals with Henry Quillian and Taylor.